Hi, this is Jonathan Ginsberg, and today is November 28th, 2007, and welcome to another edition of the SSD radio podcast, or video podcast in this case. Today what I want to talk about is a hearing that I actually just came back from in Macon, Georgia. Hearing was scheduled today at 1 o'clock. It's now about 4:15, so I literally just got back in the office about 10 minutes ago, and I wanted to talk about this while it was fresh in my mind. This was a case for a client of mine who has basically some overall body pain, basically a bad back, and I'll talk about the specifics of the case in a second, but I wanted to tell you about a couple of things that were kind of interesting about this hearing, which was sort of new. First of all, normally when you go down to a hearing, at least from the attorney's side, you check in and you sign in. You usually have to show some ID, and then at that point you ask for the file to take a look at the file, and what I typically do is compare what's in the court's file to what's in my file to make sure that my notes are up to date. And what I do, I pretty much take everything and put it into sort of a two-page summary. I call it a little hearing worksheet, and what I do is I take all the basic elements of the case. I will put the claimant's name, the social security number, date of birth, onset date, date last insured, work history, and then I summarize the medical. So I may take 3 years of medical in each sort of section of it, if you will. Might get a sentence or two, so I can pretty much go through chronologically what's going on with my client's case in 2 or 3 pages. And that's a big help. So instead of having to flip through a big file, I've got it all right in front of me, and if the case file is numbered, which hopefully it will be, I can refer specific to a number, so that really saves me a lot of time. So I usually do this ahead of time for obvious reasons, and then if I'm missing something, if there's something I haven't seen before, I can add it in. Typically I take my laptop, so this is all on the laptop, and I add it in, and that's that. Well, this time, because it was in Macon, what I usually do when I'm out of the city, rather than get the file ahead of time, although I will sometimes do that, I usually get down there a couple hours early and I'll go through everything. Well, here when I went down there and I said, can I see the file, they gave me this. And this is obviously not a big thick file, this is a CD. And basically what they've done now is they have gone and eliminated the paper files, at least in the Macon hearing office, and they're putting all the exhibits on CD. And once I kind of saw that, and they actually have a little area there where the attorneys can meet with their clients, where they have a computer and a reader for this, and I had to kind of figure out what the reader would be for my own laptop. But basically this is kind of nice, because now hopefully I'll be able to get these before the hearing. I'll have everything in front of me. This is all the exhibits. They weren't numbered, so that was kind of strange, but it does give me everything, and I can refer to it, and theoretically we'll be in the actual hearing room with a computer, and the judge will have his computer, and we can all be looking at the same thing. If we need to refer to a specific exhibit, we can do that. But if you're an attorney and you are trying cases, I suspect we're going to start seeing this more and more in the hearing offices, so you need to find out what kind of reader will work for this. It's not a PDF reader. These are in what they call TIFF format. I have no idea why they would use TIFF format instead of PDF, and I guess that would be too logical, but TIFF is another document compression format, and many readers can read it. You can buy them and get them free. There's one I downloaded for free, actually, at the hearing office. I logged in wirelessly, and I went to the internet and I found a reader for it, but just be aware that they're doing this now. So that was kind of an interesting change, and actually it's a welcome change. I think this is something that would maybe go a long way to speeding things up a little bit and avoiding making photocopies, wasting a lot of paper for no reason. So, in any case, let me tell you about the hearing itself. I thought this was kind of an interesting case to talk about, and I'm going to write this up as a case study on one of my websites, but just so you can kind of understand what went on. This is a lady who was 59 years old. She has a high school education and past work at a large sort of discount chain store as a photo lab technician, and then prior to that she'd worked as a teaching assistant at a school for disabled adults. But basically 2 jobs in the last 20 years, other than 1 year when I think she had some surgery and was moving. Pretty much a consistent work history. Both these jobs she was at for 9 years one and 10 years the other. She's 5'2" and 220 pounds, so she's got some weight issues. Again, a high school grad. And the problems here are basically back pain. This lady has got pretty significant back pain, such that she tells me that she can basically sit for 45 minutes to an hour, then she's gets uncomfortable, has to stand up. She can stand for no more than 10 or 15 minutes at a time because of the back pain. There's evidence to suggest there's extensive degenerative changes throughout her spine. She's got bulging discs, and she's got disc space narrowing and so forth. Although no herniated disc, no smoking gun, if you will, no trauma. It was simply just, I think a combination of the weight and age left her where her back is just really a mess. And her testimony is that she really can't sit for more than 30, 40 minutes at a time. She stands up 15 minutes. She can do this for maybe 3 or 4 hours during the course of a day. And after maybe 3, 4, 5 hours at most, she has to lie down because she's in so much pain. She's got a couple other things. She's diabetic, which I suspect makes it harder for her to lose weight and maybe to recover, her body to recover itself, I guess. And she's also got hypertension. She's got some vision issues, although in her mind she told me that she has a real hard time focusing and seeing things, but the medical record here was not real supportive of that. And basically the doctors who Social Security used basically said that her vision problems were mild at best. So I decided when we were talking about it, I said, even though I understand that you believe that you've got some vision issues, and I certainly understand that and respect that, I think that's probably not our strongest argument. So in any case, basically I saw this as a back case. We started the hearing. The judge asked me for sort of a preliminary opening statement, and I gave him that. I pretty much said to him, Your Honor, my client is 59 years old. She's got past work, pretty consistent past work at 2 main employers. Her past work is either unskilled or it's semi-skilled with no transferable skills, and her problem is essentially a back problem. She's got significant degenerative changes, constant levels of pain, such that she's only functional 3 or 4 or 5 hours at most during the course of a day. She has some other things going on, but nothing really significant, primarily a back pain case. The judge, I think, appreciated the opening, and he basically just asked her a few questions to establish her credibility, and really after about maybe 7 to 10 minutes he decided he was going to go ahead and grant the case. He really didn't ask her any questions significantly about her condition. He just asked her a couple of things about her ability to sit, and she said, I can sit for an hour, but then I've got to stand up and walk around, and I can repeat that cycle 2 or 3 times, and that's pretty much it. And the judge made mention of the fact that her work history was so good. And I think this is something that you see on an ongoing basis, and that is with this lady, she's had 2 jobs over the course of essentially 20 years. She's worked for 30 years, and with the record in Social Security only goes back the past 20 years, but she's got 30 years of earnings record, pretty consistent, except for maybe a short time when I think she moved or had surgery. The judge was very impressed with that. So I think what I think we can learn from this is that when you are applying for disability, one of the things that the judges find very relevant is your work history and the consistency of your work. A lot of different jobs don't really impress them, but 1 or 2 jobs that suggests that, hey, this person really was trying to work and trying to make something of him or herself. In fact, I told my client prior to the hearing, I said, you really want to emphasize to the judge that even though you're here, you're applying for disability, you don't want to be here. Disability is the last thing that you want to be asking for, but you can't work. Not that you don't want to work, but you can't work. And she did. I also told her, I said, the judge is going to ask you why you can't do a sit-down type of job. And he did, and she had a hard time explaining that, and I told her, I said, you need to just explain that you can sit for an hour, but then you got to stand up and move around, but that cycle can only go 2 or 3 times during the course of a day. And I also told her he was going to ask her to rate her pain on a scale of 1 to 10, which he did. So pretty much he asked every question I thought he was going to ask, so she was pretty well prepared from our pre-hearing meeting, which I think is also very important. If you're applying for disability, make sure that you meet with your lawyer ahead of time and practice the questions you're going to get so you won't be surprised by them. Because that 1 to 10 question is hard, because a lot of people think, well, when I'm sitting it doesn't really bother me, but when I'm standing it's really bad. So I said the way you describe that is that your pain ranges. When you're sitting it's maybe a 1 or a 2. When you stand up after between 5 and 7 minutes it starts to jump up, and by 10 minutes it's at 8 or 9. And that's something that a judge can understand. So you got to really quantify a pain, which is certainly a qualitative type of thing. So this case actually went quite well. Again, only about 10 minutes. I think the judge was very impressed by her work history. The medical record was consistent. Interestingly, we did not have any kind of form from the doctors. I didn't have a functional capacity form or any letter from the doctor stating that my client had these specific work limitations. But she had an ongoing history of visits, complaints of the same thing, of this chronic back pain. prescribed a lot of medications, although she testified she didn't always take them because they didn't really help her. But this was a very credible witness. So what we had here was we had consistent medical treatment. We didn't have a really strong form from a doctor, but we had a very, very credible witness. And that credibility, I think, was ultimately why the judge decided to approve this case. So that was what happened here. The lady was very happy about that. I also had an argument in my back pocket I didn't really need to use, although I did mention it briefly at the opening, and that is this lady, I think, met the grid rules. And the grid rules I talk about on the blog and also some of the websites. Basically, Social Security recognizes that somebody who is age 50, 55, 60 is going to have a much more difficult time entering into the workforce than a person who's 20 or 30. And so they created these things called the Medical Vocational Guidelines, or in other words, the grid rules, and I'll have a link to that next to this post. But these grid rules basically say that if you have a physical injury and you are limited to a certain level of work, sedentary work, for example, which means sit-down work, that you can still be found disabled even if you can do sit-down work if you have a limited education and no real transferable skills into the workforce. And if you hit age 55, you can do that at light work, and there's even some levels where you can be medium work, and medium work is, I think, lifting 20 pounds regularly. You can still be found disabled under certain circumstances if you have a very limited education, very poor command of the English language, no transferable skills. So it's always worth looking at if you're over the age of 50 and you have a physical problem, whether the grid rules might apply or there might be some structure where they could apply. I think the judge, I don't know that he had recognized that right away. I mentioned it and he made note of that, and that certainly makes it easier, because when he's doing his hypothetical question, if he finds that the person is going to be disabled at sedentary, then the hypothetical question at light, meaning that the judge has got to create a hypothetical where the person's able to do light work, much more difficult to do, and makes it much more likely for the case to be approved. So that was my experience today. Again, just to recap, when you go to these hearings in many hearing offices, the hearing file is going to look like this, a lot thinner than something that looks like this. And as for the attorneys, if you're prepared for it, it's certainly a good thing. I think that if you are doing this type of work, either make sure you have the right kind of reader, or try to get a copy that's ahead of time so you can look at it. I can imagine if you don't have the right kind of reader on your laptop and you go into the hearing office, that could be a real problem. And then the second thing is that work history, second lesson from today is that work history, very, very important. Judges find that very, very relevant to your credibility. So if you've got a work history, really focus on that. That's a very important factor. So that's pretty much it for today, the 28th of November. We're heading towards the end of the year, and hopefully the podcast and video blogs I've done this year have been useful to you. We had a lot more planned for 2008. And hopefully I'll be able to do another one of these, or one or two of these, before the end of the year. But in any case, that's it for today. This is Jonathan Ginsberg signing out.